Hi there. It's Wednesday, April 20th, and we're going to be heading into our second day of the hearing at the Canadian Constitution Foundation's challenge to the British Columbia government's vaccine passport policy. I'm about to head off to court. Today is going to be mostly the government making their submissions in defense of their discriminatory policy. The Canadian Constitution Foundation made their submissions yesterday on behalf of the organization and on behalf of the three individuals who have been adversely impacted by that policy. I'm going to be live tweeting all of the updates if you follow me at C Van Gyn, so you can watch all of those updates there. You can also check back later if you missed the live updates to read about how the day went. At the end of the day, we're going to be having our reply, and I'm going to finish this video with an interview with the Canadian Constitution Foundation's lawyer, Geoffrey Trotter, who's been doing an incredible job in court this week. Wish us luck today in court. We've just wrapped up the second day of the hearing in the Canadian Constitution Foundation's challenge to the British Columbia vaccine passport policy for failing to accommodate medical exemptions. We had 2 long days of hearings. It was really fascinating. If you want to see what happened, you can see minute-by-minute updates on my Twitter thread at C Van Gyn. But I'm here now with the Canadian Constitution Foundation's lawyer, Geoffrey Trotter, to break down how the day went. Hi, Geoffrey. So we just wrapped up the hearing, and I want to know, what were your major takeaways? How did the first and second day of the hearing go?
Well, I'd say that the Chief Justice was very interested in the arguments yesterday. He asked them insightful questions about the evidence, but today was especially interesting because there was a lot of pushback on some of the government's positions and some interesting concessions.
So what were some of those concessions that the government made? That's really interesting that they did make some concessions today.
So one of the government's key arguments was that we shouldn't be allowed to come to court at all because our 3 individual petitioners had not gone to the PHO with their own exemption application. Our position has always been they couldn't do that because they were outside of the closed list. That's kind of the foundation for the whole case. And the government lawyer ended up conceding today that for at least Ms. Cassian, based on the rejection she'd had earlier from public health when her own GP and neurologist had said, we don't think she should be vaccinated, that there was it couldn't be reasonable to deny access to the courts when they'd already made that decision.
So the judge asked a lot of questions today. Is there anything that he said that is sort of substantial that we can take something away from? Is there anything you can read into questions that are asked from the bench? What do you have to say about that?
So you never want to read too much into questions, but one of the interesting ones is I'd made the point yesterday, the PHO has argued, this is all about the broadest possible conception of public health. It's about avoiding overwhelming hospitals, avoiding deaths, and so on. We've said, look, we're just challenging the inadequate medical exemptions of the vaccine passports. You can't raise the broadest possible objectives. And one of the things we pointed out in support of that is, look, you can be an unvaccinated employee in a restaurant and still go to work, but you can't be an unvaccinated patron in a restaurant. So, the PHO is already accepting a certain amount of inherent risk that not everybody is going to be vaccinated. And that really undermines their argument for this kind of super broad, we've got to minimize risk everywhere we can. And Chief Justice Hinkson put his finger on that today and asked the government about it. They went away and thought over it over the break, and they came back, and the best they could say was, well, it's really important that people can continue working. But I mean, look, for someone like Ms. Shire, who needs access to the public pool for medically essential therapy, it's the only way she can get exercise given her disabilities, that's got to be at least as important as going to work.
So one of the things that the government had argued at the beginning of this hearing was that the case was moot, that the vaccine passport policy has been repealed in British Columbia, so we shouldn't even be hearing this case. What did the court have to say about that argument?
Yeah, well, firstly, I mean, it's super interesting that the orders were repealed like less than 2 weeks before this hearing. You can read into that what you wish. But the court said pretty early on in my submissions yesterday that I didn't need to take a lot of time on mootness, that the court recognized that given Dr. Henry's own statements that the passport regime could come back if things worsen again, particularly in the fall respiratory season, that he was inclined to decide the case.
So the case involved sort of three main factual disputes. Can you sort of summarize what those three issues in dispute were?
Yeah, so the first factual point was we said that the PHO's own documentation and the mandatory form for applying for an exemption had a closed list, and that if your condition was not on the list, you were just out of luck. You couldn't even apply. So if we win on that, then we, in our submissions, ought to win the whole case. The second was, even if the PHO own exemption forms aren't quite that determinatively narrow, even if there is some wiggle room to consider other conditions, that the way it was communicated to the public and to doctors, especially through the College of Physicians, was a very clear direction that you can only give a medical exemption letter in support of someone who's on the PHO's own list. And the language was pretty strong in some of those college communications. So, even if, theoretically there's a bit of an open category, that was certainly not the way it was communicated to doctors. And the third key point was we said, look, even if there was an open category for applying for some other disability, that the way the system was structured from November until after we got the hearing dates in this case was that the PHO would only grant an activity by activity exemption. So you'd have to apply to go to Christmas dinner. You'd have to apply to go to your dance class, and over. So the exemption would be all but illusory for most people who don't know weeks in advance and don't have the time to put together a complicated application just to be allowed to do something that they're lawfully entitled to do anyway.
So one of the things that happened that was really fascinating in the hearing was the government had argued that this application was premature, that the applicants, the three individuals, should have sought reconsideration to get these medical exemptions through the process. And Chief Justice Hinkson asked the government, if they sought that relief, would it be granted? And what can you tell me about that question from Chief Justice Hinkson, what the government's response was, and what happened with that?
Yeah, so Chief Justice Hinkson sent the government lawyers away over the lunch hour to get instructions about whether the PHO would consider essentially retroactively treating the court proceeding as a request for an exemption, and if so, what the answer would be. And the government lawyers came back after lunch and said the PHO is not willing to treat it that way. The orders are repealed anyway, and some other technical reasons. But the point behind the question, I think, is they had the evidence since December and January about our client situation, yet they never actually came out with an answer about whether their conditions would qualify or not. And so how can our clients not be allowed to at least come to court to get some relief? So all of that, I think, hopefully bodes well for us.
The last question is, what is the relief that you're seeking from the court? What would a win today look like?
Yeah, well, unfortunately, the court process, it took a while to get here. And so it's too late to give our clients the 7 months of their lives back where they weren't allowed to do all these things that everyone else was allowed to do. But what we are seeking, and the government lawyer conceded is available, is a declaration that the government did breach our clients' constitutional rights in the past, up until April 8th. And for the court to describe in its reasons for judgment that these exemption provisions were too narrow. They failed to accommodate some people with disabilities. Those who were on the list were accommodated. That's great, but our clients were not. And for those public reasons for judgment, then, to inform the government's consideration of how it has to restructure and broaden the exemption regime going forward. And we hope that will be a useful precedent across the country if we're successful.
So I said that was my last question, but I do have one last one. How long does it usually take to get a decision in a case like this?
It varies greatly. Chief Justice Hinkson ruled just within a matter of weeks on another constitutional challenge a year ago, but that was during a time that the orders were still effective. And the Chief Justice is actually hearing 3 other petitions that are challenging different aspects of these vaccine passport orders. So my guess is we'll hear kind of sometime this summer. I do think he's going to try to rule before the fall, which is when Dr. Henry has said we might see these again, depending on the trajectory of the pandemic.
Okay. Well, Geoffrey, thank you so much for everything that you did in this case. You did a really amazing job. I think that this would be the first case, if we win, with a successful challenge to the COVID regime, like a really successful judgment. So I am really optimistic. I think you did an incredible job. So thank you so much for all of your hard work on this case. I'm looking forward to the decision.